Welcome to our practice exercise debrief, applying 18 U.S.C. Section 207C to a set of proposed post-employment activities of a senior employee. For purposes of our exercise, our senior employee is Gabriela Torres, and she is a senior employee with the National Archives and Records Administration. We'll be using this worksheet to apply the 207C elements to her proposed post-employment activities to decide whether she will have any restrictions on any of her activities. While we will be confining ourselves to a 207C analysis for purposes of this debrief, I will be periodically reminding you that our senior employees also have potential 207A1 and A2 restrictions, and therefore they may need you to provide them with advice on those restrictions in addition to 207C. We're going to be making reference to the implementing regulation at 5 CFR Part 2641, including some aspects of the preamble to the final rule. We're going to be making use of some excerpts of the summary of 2641. We're doing that for visual as well as discussion facility. When you are providing advice to your employees, we advise that you only use the actual text of the regulation themselves. So is Gabriela a senior employee? Gabriela has told us she's a senior employee, and we're going to take her at her word. But for purposes of our own edification, we're going to be looking at the definition of senior employee. Senior employee is defined by statute, and it's found in the regulation at 5 CFR 2641.104. Now, while there are 6 separate bullet points here that describe how one can be considered a senior employee, we're going to be looking at bullet point 2, because this is likely where our employee, Gabriela, is defined as a senior employee, and where many, if not most, of your senior employees are going to be defined. And that is any individual whose rate of basic pay is equal to or greater than 86.5% of the rate for level 2 of the executive schedule. That's going to be most, if not all, of your career and non-career SES and SES equivalents. Now, rate of basic pay does not include locality-based adjustments or things like awards and bonuses. In order to calculate the 86.5%, OGE does this for you every year and provides you with a dollar amount for that calendar year. For 2020, 86.5% of level 2 of the executive schedule is $170,665. So that means anyone whose rate of basic pay is equal to or greater than $170,665 is going to be subject to the 207C provisions. Now, you may ask, well, does that mean that certain GS-15 employees, if they meet or exceed that dollar amount, are then considered to be 207C senior employees? And the answer to that question is no. GS-15 employees' rate of basic pay includes locality-based pay. So in order to determine if a GS-15 were subject to this, you would have to back out any of the locality-based pay that they were receiving, and that rate would not be equal to or exceed $170,665. As we mentioned in the introduction, SGEs and IPAs are subject to 207C, but not all are. For SGEs, it's only going to be those who served in a senior employee position for 60 days or more. For IPAs, it's only going to be those who received a total pay that was equal to or greater than this 86.5% of level 2 of the executive schedule. So we know that Gabriela is a senior employee. She has told us so. And we know that she is a current employee. She has not yet left senior service or government service, but she's anticipating doing so September 25th of this year. So her 1-year bar will begin from the date that she terminates her senior service. In Gabriela's case, it looks as though that's also going to be a termination from government service. What are Gabriela's post-employment plans? She's told us that she plans to work part-time for the Maryland State Archives. She's also told us that she is going to be an unpaid volunteer serving on a committee for the Society of American Archivists. Now, do we have to know what Gabriela actually did for NARA in order to provide her with any 207C advice? And the answer to that question is no. Unlike A1 and A2, where the restrictions are tied specifically to specific party matters that the employee either worked on or had under their official responsibility, 207C is not tied to any of the duties that Gabriela may have performed for the National Archives. Now, what do we need to know about her proposed part-time position with the Maryland State Archives before we provide advice to her on 207C? The Maryland State Archives is a prospective employer that actually may enjoy one of the exceptions to the prohibitions on 207C. We're going to talk about that exception a little bit more specifically later in our analysis. But for right now, it's enough to know that there is an exception that exists for instrumentalities and state entities that could apply to this, but it's going to depend on what her part-time position actually is with respect to her status with the Maryland State Archives. If she will be an employee of the Maryland State Archives, she will be able to enjoy the exception to 207C. If she is other than an employee, say an independent contractor, then she will not have an exception to 207C and will be subject to its restrictions. So what is an appearance or communication? Actually, for the next three elements of our analysis, which is appearance or communication with the intent to influence on behalf of any other person, 207C does not differ from A1 and A2. So what is an appearance or a communication? A former employee makes an appearance when she's physically present before an employee of the United States, and that's either in a formal or an informal setting. And although an appearance may be accompanied by communications, an appearance doesn't have to involve any communication by the former employee. Now, we're going to talk a little bit later about when would someone's mere appearance without communication be deemed to be an appearance with the intent to influence. So we're going to just put a pin in that, and we're going to come back to that in a minute. So what's a communication? A communication is a fairly straightforward, commonsensical concept. A former employee makes a communication when they impart or transmit information of any kind. That includes facts, opinions, ideas, questions, or direction. And whether orally, in written correspondence, by electronic media, or frankly by any other means. But it's only going to include communications with respect to which the former employee intends that the information conveyed will be attributed to him or herself. So this is a third-party intermediary concept which is integral to the concept of when you're actually making a communication as opposed to when you are confining yourself to behind-the-scenes assistance. So an employee may engage in behind-the-scenes activity provided that they're not actually making a communication that would basically be done through a third party with attribution intended to the former employee. The regulation acknowledges that behind-the-scenes assistance as a general proposition is okay, provided it doesn't involve a communication or appearance before an employee of the United States. And in our example, where we talk about what behind-the-scenes assistance, permitted behind-the-scenes assistance would look like, in our example, we make it clear that it would include things like preparing a paper that describes the people at your former agency who should be contacted, or what should be said to them in an effort to, for example, increase the scope of funding on a contract, or to resolve a dispute over a contract clause. For example, we say those are all permissible activities provided that there isn't a communication where the former employee intends to be recognized as the source of that information. This third-party intermediary concept is discussed in our preamble to the final rule. You can find it in the section that discusses the communication and appearance elements. Example 5 to paragraph D illustrates how this can come about with an illustrative example. And this example is taken directly from an OLC opinion that was issued in January of 2001, and it was addressing a 207C circumstance. And in the OLC opinion, a former senior employee had created a consulting firm after leaving government service, and their consulting firm prepared a report for one of its clients. And that client submitted that report to the former senior employee's former agency. And the totality of the circumstances indicated that the former senior employee intended that the information in that report be attributable to him. And therefore, it was a third-party intermediary communication in which the former senior employee indirectly, through their client, made what would otherwise have been a prohibited communication back to their former agency. So when we are providing advice on behind-the-scenes assistance, particularly to our former senior employees, it is imperative that we give them examples, that we help to explain to them what circumstances might be likely to implicate the third-party intermediary concept and how they might go about confining themselves to behind-the-scenes assistance. So a communication or appearance has to be made with the intent to influence. So what is an intent to influence? We say an intent to influence is present when the employee is basically seeking a discretionary action on the part of the government. So it can be a ruling, a benefit, an approval, but it's basically anytime that you're asking the government to exercise discretion in providing a service or in engaging in some action, that would be an intent to influence. Likewise, if you're you're asking the government to take an action in a context where there is some adversariness, there's some dispute or controversy. That would also be a circumstance in which your communications would appear to be made with the intent to influence. We say, generally speaking, that you're not engaging in an intent to influence if the communication is solely for purposes of making a social contact, engaging in a social visit. We're going to be talking later about circumstances where we have to be really careful because just because the venue looks like it's a social venue does not necessarily mean that the communications that take place therein would not be communications with the intent to influence. We also talk about when there is an intent to influence, when or not an intent to influence, when you're conveying certain types of quote unquote purely factual information. Again, we're going to be looking at a few examples where we differentiate between when are you really asking for factual information that is not going to be an intent to influence, and when is it that even though it does look like it's just factual information, that the totality of the context makes it appear as though your intentionality is to do something more than just receive or submit factual information. There are additional specific activities that are articulated in the 4 bottom bullets. I would caution you against attempting to extrapolate from those very specific examples to other examples you might encounter without at least consulting with OGE. These are largely a reflection of policy decisions that were made before the regulation was issued, and the regulation is in many ways simply grandfathering in these prior policy decisions. So if you have what you think is an analogous situation, please contact OGE before using these 4 stipulated points as your justification. So let's ask ourselves the question. We talked about this a moment ago in the context of appearance. So may Gabriella merely attend official meetings with her former NARA colleagues? May she simply appear in a room in meetings with her former NARA colleagues? There's a provision in 2641.201E4 which addresses this directly. When does mere physical presence, when is it with an intent to influence? And we say that under some circumstances, a former employee's mere physical presence without any communication whatever may constitute an appearance with the intent to influence. And then we give some relevant considerations for this mere physical presence. We're not going to get into what those factors are because they're going to be very fact dependent on the circumstances that your former senior employee would be facing and would want to be engaged in. I will say this, though, with respect to when it involves a former senior employee. Now, this provision applies under A1 circumstances as well as A2 circumstances. But in the case of former senior employees, I think we constantly have to be mindful of what 207C is trying to prohibit. And it is trying to prohibit a former senior employee who clearly had authorities that were consonant with the level of responsibilities that they had from being able to exercise undue influence, from being able to exercise an ability to gain access to policymakers in their former agencies on behalf of others, and do so in a way that is unfair and would appear to be misusing the privileges of their former position. So I think with respect to folks who are subject to 207C, we have to take this particular provision very seriously, that because they were powerful people, there is a vestige of power that still resides with them, and their mere presence in a room may very well have some intended effects, even if they never, ever speak. I've given you, as by way of example, this is from a 1993 conflict of interest prosecution survey, and I don't want to talk about this at length, but this was a circumstance where a former senior employee from the Federal Reserve, once they left the Federal Reserve, were elected to the boards of directors of various companies. Kroger was one of them. And Kroger had some issues with a guideline that the Fed and other agencies had issued. And in response to a request for public comment, Kroger submitted comments. And then they attended a meeting with a member of the Federal Reserve Board. Now, that meeting was arranged by the former senior employee within 1 year after leaving senior service. And in addition to arranging the meeting, the former senior employee actually attended the meeting. And while the only thing she did was to introduce all the parties around the table to each other, and then she said nothing more for the rest of the meeting, she was paid by Kroger to participate in that meeting. And this activity, the arranging the meeting and then attending the meeting, became the subject of a criminal investigation. Now, there was a settlement agreement. I'm not going to go into what the settlement agreement was because you can read that on your own. But I think it's important to have a concrete example of where this exact thing, where someone appeared without communicating anything substantive, was at least one of the considerations that led to a criminal investigation. So may Gabriella provide information or comments or otherwise express opinions to NARA on regulations or on other issues. Here, we're always going to have to deal with as a primary focus whether or not she would be doing it in a self-representational kind of way. And I think it's always important for us to be able to articulate to our employees in their post-employment advice circumstances where they may be able to communicate on their own behalf in particular, as well as the variety of ways in which they won't be able to appear or communicate before the agency. So we have an example in the regulation where we talk specifically about that, the kind of a communication that if you do it on your own behalf is perfectly okay. So we have a Bureau of Land Management employee who participated in a decision to grant a private company the right to explore for minerals on certain federal lands. The employee retired, to pursue her hobbies. So we don't have any indication that she's, that she has anything else going on where she might be acting on behalf of someone else. So she's engaged in hobbies. The former employee becomes concerned the BLM is misinterpreting a particular provision of the lease. So she is allowed to contact a current BLM employee on her own behalf in order to argue that her interpretation is correct. That would not be a prohibited communication because it's clear that she's doing it on her own behalf, even though she's sort of taking them to task for something that's very substantial. This isn't a ministerial contact. This is very much a substantive contact, but it's done on her own behalf. So we're going to come back to that notion of, okay, so what about when you're doing it on behalf of someone else? Where do you draw lines? We're going to come back to that when we talk about on behalf of. But for right now, I want to address another not intend to influence consideration that reaches to this notion of when you're asking for or when you're presenting quote unquote factual information. So we have two examples to look at here. In the first one, we have a former DoD employee gone to work for a DoD contractor. He's working on producing an operator's manual for a radar device that DoD is asked for. And so in the process of developing this manual, he calls up a DoD employee because he wants to ask certain factual questions about the device and its properties and how it functions. And we argue that, well, this discussion does not appear to concern any matter that is known to involve a potential controversy between the agency and the contractor. So we say the former employee hasn't made a communication with the intent to influence simply by asking for clarifying questions about the technical nature of this thing that he's working on. So we're looking not just at what were the questions. Were the questions factual? We're looking at the totality of the circumstances. Was there any potential for controversy or whatever? Or were these just literally, I need this information in order to produce the document that you're asking? We contrast that with example 4, where we have a former medical officer from the Food and Drug Administration has sent a letter to the agency. And he's setting out certain data from the safety and efficacy tests for a new drug for the company he now works for, because they're seeking approval from the FDA for this drug. And we argue that even if the letter is confined to arguably factual matters, such as a synopsis of the data from the clinical trials, the communication in toto is made for the purpose of obtaining a discretionary government action, the approval of the drug. So therefore, this is a communication made with the intent to influence. So again, we're not going to try to say that because there are aspects to the communication that are dealing specifically with facts, and so facts are allowed, that we get to ignore what the overall intention of the communication is. The overall intention of the communication is to persuade the FDA to approve this drug. So just to give you a little distinction between when is factual information sufficient to let us know that there's no intent to influence, and when are we looking at a totality of circumstances where we don't really need to just focus on whether the nature of the information is factual, but what the overall intentionality of the communication is. So who besides Gabriela should be counseled on post-employment communications and appearances by former senior employees? And I think this is a really, really, really important question. I would ask you to seriously consider in your annual training routinely having an aspect, particularly for those employees who are most likely to receive post-employment communications by former senior employees. And that is to let those employees have an opportunity to practice what they will actually do when this happens, because it probably will happen. They will get a communication or an appearance by a former employee, and they themselves have to know what is prohibited and what is permitted so that they know how to conduct themselves so as both not to pull a former employee into an inadvertent violation of 207, but also themselves to make sure that they're not engaging in or enabling a violation of law. So when is the appearance or communication on behalf of another? Any other person means both individual persons, human persons, as well as legal persons, such as corporations and organizations and state, local, and foreign governments. And certainly it includes any officer, employee, or agent of any sort of legal person. It would extend to an employee's own business if the employee post-employment were to establish a business and incorporate it. The incorporation would make it a third legal person, and then when they were making representations on behalf of their business, they would be making representations on behalf of another person. When is there agency? Well, you're acting on behalf of a third party if you are formally acting as their agent or attorney. But there's sort of a less formal concept of agency that we have to be aware of as well, which is if you're acting with the expressed or implied consent of that third party and you're subject to some degree of control or direction, and I want to emphasize that, control or direction by the third party. So when might Gabriela be communicating on her own behalf, and when is she communicating as another's agent? We touched on this a little bit before when we looked at the BLM example. And so we kind of have that as our example of when one might be communicating on their own behalf. For Gabriela, it's going to be a little bit more difficult because she has these other positions she's going to encumber when she's in a post-employment environment where she's going to have to be mindful of when she may actually be communicating or appearing on behalf of either the archives or the society. So let's look at example 2, which is a build on from example 1. The former BLM employee from the previous example later joins an environmental organization as an uncompensated volunteer. So that sounds like Gabriela's work. She's going to be an uncompensated volunteer with the society. The leadership of the organization authorizes the former employee to engage in any activity that she believes will advance the interests of the organization. This is very similar to what I've actually read on the society site. The society is an actual society, and in fact, that committee is an actual committee, even if Gabriela is not an actual human being. And they have a similar stipulation with respect to their uncompensated committee members, that it's understood that they have the ability to act with the consent and approval of the society. She makes a communication on behalf of the organization when, pursuant to this authority, she writes to BLM on the organization's letterhead in order to present an additional argument concerning the interpretation of the lease provision. Now, although the organization did not direct her to send the specific communication to BLM, the circumstances established that she made the communication with the consent of the organization and subject to some degree of control or direction by the organization. So again, we don't want to be getting too literal with the notion of agency. In Gabriela's situation, if she's acting on behalf of the Maryland State Archives as their employee, she's clearly would be acting in those contexts as their agent. With respect to the society, the fact that she's an uncompensated volunteer, to the extent that she's making communications that seem to be consistent with the interests of the society, and there is an indication, even if it's not on their letterhead, that when she is communicating, she is doing so with their either expressed or implied consent, and she's at least subject to some degree of control or direction. It doesn't mean that they have to be literally controlling and supervising her every action. If there's some understanding that she's acting with agency from them, then she's going to have to be careful about any communications she makes that are in association with activities she's undertaking on behalf of the society. So what is to or before a senior employee's former agency? Now here is where 207C departs entirely from A1 and A2. A1 and A2, the restriction is as to an employee of the United States. Here it is to or before an employee of the former agency. So we're going to start by talking about what is a former agency, and then we're going to come back to what's an employee of the former agency, and then where you served in any capacity, because that's the other piece of it. It's any agency where you served in any capacity during the 1 year prior to your termination from senior service. So an agency for purposes of 207C is generally speaking going to be the entirety of the organization in which the employee serves. However, in some circumstances, and this is going to be particularly true for departments, they are eligible to create subdivisions for purposes of 207C, where they are in effect creating separate independent agencies for purposes of communications under 207C. And if a department or agency has done that, is eligible and has done so, those separate component designations are published in 2641 in Appendix B. Now, just for purposes of explaining how these work, it's much easier to just give you a for instance than to continue talking in regulatory language. So quickly, I'm just going to talk about if your department or agency is subject to these and you have these in place, this is how they operate in effect. So we're looking at the Department of Justice, and in the center we have the parent. The parent is Main Justice. And then the satellite components we have around them. And these are not all of the component designations that the Department of Justice has. These are just a representative sample. So what this means is if you were a senior employee at FBI and you leave senior service, you have restrictions only as to the FBI. You do not have restrictions with respect to Main Justice or to any other of the components of justice. You are restricted only as to the FBI. The same thing holds true for EOUSA, Bureau of Prisons, etc., etc. For those who are senior employees at Main Justice, they will have a restriction under 207C as to Main Justice and as to any other undesignated components of justice. But if you were a former senior employee in Main Justice, you do not have a 207C restriction with respect to the FBI, with respect to the Bureau of Prisons, with respect to EOUSA, or any other agency that has a separate component designation. That's how that works. So what's an employee of your former agency? For purposes of this part, employee means obviously anybody who's a current employee of the agency, they're covered. That's self-evident. But it's also going to reach to any individuals who are detailed to the former agency from another department, an agency, or entity, which includes those within the legislative and judicial branches. So people who have been detailed to your former agency are now going to be employees of your former agency, and so your communication restrictions are going to apply to them as well. It's also going to apply to any individuals who are serving with the former agency as a collateral duty pursuant to either a statute or an executive order. This happens quite a lot with particularly higher level officials who have simultaneous responsibilities by dint of their position. So their position may be with the Department of Transportation, but they have collateral duties that to serve on committees or commissions or advisory boards in other departments and agencies that are considered to be part of their responsibility. So those collateral duties then make them employees of those agencies for purpose of 207C restrictions. With respect to people who have restrictions as to the executive office of the president, employee is going to include the president and the vice president. So what about served in any capacity? This is effectively a one-year look back from the date of termination from senior service. If the former senior employee served in any capacity in any agency, those agencies are going to be captured for purposes of their 207C post-employment restriction, and it doesn't matter whether they were serving in those capacities as a senior employee. So it's a one-year look back that captures any service in any capacity in any other agency during that last year prior to termination from senior service. So understanding that, may Gabriela contact the Department of Justice to request a speaker on anything? We say FOIA and Privacy Act, but basically on anything. And the answer to that is, well, unless she somehow served the Department of Justice during the last year before she terminates, she won't have any restrictions with respect to contacting the Department of Justice or frankly any other executive branch department or agency other than the one where she served. May Gabriela serve as a speaker or a panelist for the society at, let's say, a conference or a seminar or some sort of thing like that that was sponsored by the National Archives. There's a public commentary provision in 2641.204 G4, which basically says that if a former senior employee is asked to address a public gathering in the venue of like a conference or a seminar or some sort of forum like that as a panelist, as a speaker, they may do that provided that it's not sponsored or co-sponsored by the former senior employee's former agency, that it is attended by a large number of people, and that a significant proportion of those attending are not employees of the former senior employee's former agency. So for our purposes, we've stipulated that it would be a conference that was sponsored or co-sponsored by NARA. And if that were the case, no, she wouldn't be able to do it. If it was just a very, very small conference that was only like a collection of a small group of people, then they would not meet the second criterion. And if a significant proportion of those people who were going to be in attendance were NARA employees, that would also be something that would disqualify her from being able to use the public commentary provision. But otherwise, this is available to senior employees to engage in exactly these kinds of activities. So what is any matter? And any matter where you're seeking official action? This is where 207C gets extraordinarily broad. It is categorically different from A1 and A2. Any matter is a very broad universe. It ranges from adoptions of broad policy options, which is some of the broadest types of matters that the government can entertain, to this more narrow set of matters called particular matters involving specific parties, and it includes everything in between. Now, if you're struggling at all with these differential concepts of matters, what's a matter of general applicability, what's a particular matter involving specific parties, we do have an advisory that we issued back in October of 2006, which you can find on our website, which is titled, helpfully, Particular Matter Involving Specific Parties, Particular Matter and Matter, which can really help you, I think, get a better handle on the different types of matters that we discuss in conjunction with the criminal statutes. It also includes any new matters that were never under consideration by the agency, or frankly, that were even of any interest to the former agency. And also, it's going to extend to any matters that are pending at other agencies in the executive branch, in the legislative branch, in the judicial branch. It's really kind of an entire universe of any kind of matter that's conceivable, provided that you're seeking official action in connection with it. So what constitutes seeking official action? Seeking official action is equally broad. A former senior employee seeks official action when the circumstances establish that he's making his communication or appearance for purposes of inducing a current employee to make a decision. You're asking them simply to make a decision or to basically act in their official capacity in conjunction with any matter. It doesn't get any broader than this. So this is why when we talk about it being a cooling off period, it is really intended to be a cooling off period. It is intended to be a no communication whatever, because the threshold for violating 207C is so low whenever you're making that communication on behalf of anybody but yourself. So to the extent that an employee has 207C restrictions, they really should be advised to the greatest extent possible that they simply should not be the point of contact. They simply should not be the person making the communications back to their former agency on behalf of any other person. Now, interestingly enough, in the regulation, we do give an example of where a former senior employee might actually be making a communication that isn't seeking official action. And I think we do this in part because we know that people develop personal relationships with other people in their agencies. And this is going to be particularly true of your career senior service, folks who've established a career worth of relationships with people in your agency. So I think it would be unfair to not give them some examples of when they might be able to make personal communications that would not implicate 207C. So we have an example here where we talk about a former senior employee at the National Capital Planning Commission and is going to contact a friend who still works with NCPC. And they want to solicit a donation for a local charitable organization. And we say the former senior employee may do so since the circumstances establish that he would not be making the communication for purposes of inducing the NCPC employee to make a decision in his official capacity about the donation. So here we're focusing on, you wouldn't be asking this person, and this person would not be likely to even be in the authority to make an official decision about whether or not to personally make a donation to a local charitable organization. It's just not an official act. So that would be something that falls outside the scope of a 207C restriction. So let's pull this back to Gabriela. So may Gabriela contact some of her former colleagues, for example, to invite them to events that the society is sponsoring. This is a situation where, because the society is a professional association of archivists, presumably some of her former colleagues are already members of this society. Some of her former colleagues may be members of the society entirely in their personal capacities. They pay for their membership, they attend on their own time. Any communication about society activities might reasonably be able to do under the color of it's a personal activity of the former colleagues at NARA, of the current employees of NARA. And so communications, even on behalf of the society to them in that context, would not be a problem under 207C because it's not seeking an official act. However, I think we can equally envision a circumstance where, for example, Gabriela is, on behalf of the society, contacting her former colleagues at NARA to ask them to participate in a conference in their official capacity, to either attend the conference in their official capacity, to be a panelist, to somehow help organize, all as official duty activities. So clearly, those types of contacts, those types of communications would be prohibited. But helping Gabriela understand what the distinctions are between those two different kinds of communications is something that you should consider doing when you're providing post-employment advice to someone in this type of a situation. The final example I've raised here, I do simply because I think it ties everything up into a neat bow on some level in terms of describing commonplace circumstances where former senior employees, particularly if they're in any way engaged in lobbying activities, are likely to seek out and or find themselves in situations where they would be communicating with former employees on behalf of others. This is a former senior employee of the Department of Defense wants to contact the Secretary of Defense to ask him if he would be interested in attending a cocktail party. So on the face of it already, it looks like, oh, this is a social event. At the party, the former senior employee would introduce the secretary to several of the former senior employee's current business clients who have sought the introduction. So now we have a social activity that clearly, though, is in the service of acting on behalf of the former senior employee is engaging in this on behalf of their own business and certainly on behalf of the interests of their business clients. So the former senior employee and the secretary do not have a history of socializing outside of the office. So we're not dealing with a deeply personal relationship here, which is the basis upon which the former senior employee is inviting or has intentionality. The secretary is in a position to affect the interests of the business clients. So clearly the Secretary of Defense is in a position to do or not do or to make a discretionary decision with respect to something that these folks are interested in. And all expenses associated with the party will be paid by the former senior employee's consulting firm. So that's kind of like the nail in the coffin right there. So now it's the former senior employee is fully acting in the context of the business interests of the consulting firm. The former senior employee should not contact the secretary. The circumstances do not establish that the communication would be made other than for the purpose of inducing the secretary to make a decision in his official capacity about the invitation. Now we limit it to that even the invitation itself is now going to be subject to an official duty discretionary decision. We're not reaching to a personal decision that has no official action ramifications to it. Just even whether or not to accept the invitation, we think is an official action on the part of the secretary in these circumstances. But even if we weren't to say that, clearly in the actual event itself, this employee is basically will be communicating with the intent to influence the agents, the Secretary of Defense. So are there any applicable exceptions? And we talked about this earlier, so now let's take a look at the exception that I referenced earlier. It's the exception C for acting on behalf of specified entities. And this says that that this applies to both 207C and D, and it doesn't prohibit former employees from making a communication or appearance on behalf of any of these entities, provided that it is made in carrying out official duties as an employee of the specified entity. So an agency or instrumentality of a state or local government, my assumption is that the Maryland State Archives is an agency or instrumentality of the state of Maryland. So it is one of the specified entities. So then our question becomes, is she an employee? Because we say that can include a part-time employee, but it does not include individuals performing services as a consultant or an independent contractor. But I think it is important to recognize that these specified entities create basically an absolution for former senior employees from any 207C restrictions with respect to representing back to their former agencies on behalf of these types of institutions. So if your agency is one where your folks often go to these types of entities, which include the state or local governments, hospital or medical research organizations, or accredited degree-granting institutions of higher education, you need to become familiar with this exception. So in sum, we know that Gabriela is a senior employee. She's going to be leaving senior service on September 25th. With respect to her activities on behalf of the Maryland State Archives, if she's going to be an employee, she will have no 207C restrictions with respect to them. If she is other than an employee, she will have the same 207C restrictions she would have as to any other post-employment employer. With respect to the uncompensated volunteer work on the committee for the society, she will have 207C restrictions with respect to the activities of that society and any communications or appearances she would make in connection with those back to the National Archives. So these communications under 207C are limited to back to the National Archives and Records Administration, because we believe that to be the only agency where she served during her last year of government service. And in that instance, because she's acting or has the ability to act fairly broadly with the consent and the direction of the society, anytime she's communicating with any NARA employees about society-related matters, she's going to have to exercise caution to make sure that she's not deemed to be doing it on behalf as an agent of the society. A few highlights of 207C. Reminder, it only applies to senior employees. It's going to apply for 1 year from the date of termination from senior service. Prohibition in 207C is much broader reaching, and it reaches to any matter, so it's much broader than A1 and A2. The restrictions in C are not tied to the former senior employee's government duties. The restrictions in C are only as to the employee's former agency where they served in any capacity during their final year of service. And please don't forget to counsel your senior employees on any A1 or A2 restrictions they might also have. Thank you so much for participating in our practice exercise.